Welcome, everybody. We're delighted that so many of you have been able to join us this afternoon. My name is Anne Dillon. I'm a family barrister at Fortescue Bedford Row. My practice is now entirely mediation. You had expected to see Sean Smith this afternoon, not me, but she's not able to be with us this afternoon and sends her apologies. But we're very pleased to have our colleague Hannah Cox with us. Hannah has a very, very busy family practice focusing on private law, children matters, and on financial arrangements. She's in court on a daily basis, where the use of language is critical to successful practice. Hannah is one of only 300 members of the bar who've been trained to cross-examine vulnerable witnesses. The focus of this seminar is the importance of changing the language of family separation. To that end, we're delighted to have Helen Adam with us. Helen is chair of the Family Solutions Group that was set up by Sir Andrew McFarlane, president of the Family Division. Now, I'm sure many of you will know Helen, but for those of you who don't, Helen started as a solicitor back in 1989 in a central London law firm, and then retrained in 2007 as a mediator. Helen was the mediator representative on the private law working group, and from there was asked to chair the Family Solutions Group. The group's remit is to consider the needs of children and parents after separation before turning to the court, to the family courts. So, Helen, just to put things into context, following the Family Solutions Group report, What About Me? I think the President asked you to set up a group to consider the importance of an impact of language in family law, because that was one of the things that was highlighted in the What About Me report. So why is the language you're using so important? And what is the impact of that language on our clients and on children?
Well, thank you, Anne, and thank you very much for inviting me to take part in this webinar. I think all of us are increasingly aware of the language that we use. We're all having to learn to moderate our language in different ways to understand different people's interests and vulnerabilities. And those who separate, and particularly the children of those who separate, are vulnerable in a time of separation. And so the language that we use around those who are separating has a really profound impact on the mindsets of the adults and therefore the behaviour and so the life experiences of the children. So although it might seem as though we're just playing with words, I think there's a lot of evidence to show that language does affect mindsets and behaviour. You only have to think about those old adverts, Persil washes whiter. Now, whether we subconsciously think that Persil does wash whiter or not, the fact is that Persil spent a lot of money on advertising because the evidence shows that we are affected by the words used. And in fact, it was George Orwell who wrote that unless we think carefully about the language used, then our familiar words and phrases will think our thoughts for us. And so we need to be mindful of the language of family law and the language that surrounds those who separate and their children, because I think it does have an impact, whether or not we think it does or not. I think the evidence is clear that it does.
Well, thank you. And maybe what we should do is just go back a bit. And could you give us a short outline of the Family Solutions Group? Because some of people here on this webinar this afternoon will know about the Family Solutions Group, but quite a few people maybe not, and about the Language Matters report itself and the highlights of that report.
Yes, so I was the mediator representative on the private law working group, which was a group of incredibly learned and experienced legal professionals across a whole range of sectors, very experienced in litigation and in court processes. And we were asked to review the operation of the child arrangements programme in the light of the rising numbers coming to court. And one of the key themes was that there are more families turning to court than need to be in court, and that there need to be better provision and better support for families before they turn to court, so that only those who actually need the court are using the court. So I said to Sir Stephen Cobby, you really need a different group of people here who aren't court specialists, making recommendations about what people need before they turn to court. And it's one of those things where you shouldn't say what you wish for, because then that was suddenly turned into my responsibility to find a group of people and to put forward those recommendations, which we did. And for me, professionally, I'd worked as a solicitor. I have many friends who are legal professionals. I trained as a barrister, sorry, not a barrister, a mediator. But to sit in a group with people from different disciplines, from child services, therapists, a county court judge, CAFCAS, an academic, National Association of Child Contact Centres, National Youth Advisory Service, a whole group of people bringing their perspectives. It was very rich, and we all learned so much from working alongside each other. So we produced our report. It was called What About Me? Reframing Support for Families Following Separation. And one of the key recommendations was that the language used in family law should change, because it's outdated, it's historical, it's all around battle metaphors and complex terminology, and it's unhelpful. So it's very, very easy to criticize something. But then the president said, can you put together some recommendations for how language should change? And we're going to be doing a little exercise with everyone here on the webinar, so that you can all think yourselves. It's very easy to criticize language, but when you're asked, well, how should it change? That's a whole difficult thing. And we are family separation specialists. We are not linguist professors. So what we did was I sent out a blank request to a whole range of different categories of people who have experience of working with separating families: magistrates, barristers, therapists, parenting specialists, CAFCAS, children's services, child consultants, domestic abuse specialists, child contact centres, solicitors, mediators, separated parents themselves, a whole load of people. And literally said, what do you think about the language used in family law for families when they separate, and what recommendations do you have for change? And it was amazing, the energy and the positivity that people threw into this and to their response. And we got all these responses back, and we looked at them all. And as you can imagine, there was a massive, massive overlap in what everyone was saying, that we want to take the fight, the battle metaphors out of family separation language, and we need to use language that's more collaborative, that's more constructive. And so we emerged with a paper which is shared really as our suggestions, our feedback, but this is a discussion really for everyone, and for everyone here on the webinar. We don't have all the answers. We are opening up a discussion about this and invite people to think about the language that they're using and whether it should be adapted. Sorry, that's a rather long answer, but that gives the sort of history of how we got here.
So, sort of in a nutshell, what should our ambitions be for the language we use?
I think, putting it most simply, we don't want our language to escalate what are already very vulnerable and difficult times for families. If anything, we need to be de-escalating them. There are some families that need the protection of the family court, and that needs to happen in a safe and civilized way. And there are other families which need other forms of support. But in all of this, we don't want to be talking up adversarial language or pitting parents against each other in a boxing ring, giving the metaphors of them being against each other. These are families going through difficult times. Some need greater involvement of professionals than others. Some can be resolved quite simply. Others are deeply complex and vulnerable. But in all of it, we need to be careful of what we are bringing to the dynamic in this family from the language and conduct by legal professionals.
I think that's very interesting. And in a way, my next question is is an extension of that, but specifically relating it to the courts. I mean, why is the language used in court so important?
Well, it was very interesting, because really we want to see the language at the school gate change. We want to see language within families change at the times that they're separating. So most families don't end up in court. So why are we worrying about language used in court? the clear advice that we've had from the language experts, and there's a wonderful organisation called the Frameworks Institute, and they were kind enough to give us some advice right at the very beginning of this project, is that you can put an awful lot of effort into changing language at grassroots, but unless language changes at the top of the power dynamic in any system, then all the efforts at the grassroots will fall to nothing. And therefore, any change has to start with the top. And I think in the world of family separation, most families don't end up in court, but it is, of course, the language of court that feeds down into our cultural language and what is said in families at the school gate and at the times that people are separating. And that is why it matters.
That's really helpful, Helen. Hannah, do you want to, from somebody who's actually working at the coalface, so to speak, in the courtroom?
Very much in the courtroom.
Yeah.
So Helen, I just want to talk a bit more about the recommendations within the report when it mentions the 5 Ps. And I think it'd just be helpful for you to run through what those are.
Yeah, so we distilled all these different papers from everyone, all these different, and there were some very, very clear principles that emerged. And for convenience sake, we've given them all Ps. They all start with the letter P. Plain English, personal, proportionate, problem solving, and pointing to positive futures. So those are the 5 principles. We also make various comments about particular words that are flashpoints. And then we've got a number of different glossaries at the end of the paper where there are suggested alternatives for words that we think are difficult. And as I keep saying, these are our suggestions. These are our suggestions for how language might change. But so look at the glossaries not as anything, it's not law or anything like that. It's our offer to promote this debate, and people may or may not disagree with some. But if we all start thinking about the impact of our language, then that's what's important in all of this.
Before we go through each of those Ps in turn, if you like, is it fair to say that the overarching proposition that we need to keep thinking about is very much, are we interrogating our use of language at every stage? And are we actually asking, are we helping this family?
I think that's right. I mean, the difficulty of helping the family for barristers particularly is that you are, as you say, at the coalface, you are paid to win in court.
Yes.
And what is helpful to a parent is by definition perhaps not helpful or not perceived as helpful to another parent. And so, there's a tension here. I think it's very different for solicitors who have the opportunity to frame the way in which a case is managed right from the very beginning before anyone gets anywhere near a barrister. So I think that the reflection that can be that goes on with solicitors is different. But the reason it matters is because there is just incredibly strong research. There's very, very, very clear evidence that parental conflict, if it continues, if it's not just a sort of passing breakdown, but entrenched parental conflict is profoundly harmful to children. And if anybody's interested, this information is on the Family Solutions Group website, or feel free to email me and I can give you I use it all the time, a little A5 flyer, but it's a summary of the research from Professor Gordon Harold and his colleagues from the University of Cambridge. And we've summarized it in 6 short bullet points. And I'm just going to read one of them. High levels of conflict between parents are shown to have many poor outcomes for children, including anxiety, depression, academic failure, substance abuse, conduct problems, criminality, peer problems, and adversely affected brain development. Patterns of conflict can even be passed on to the next generation. So the level of conflict existing between 2 parents is scientifically proven to have a profound impact on the mental well-being of their children, and that's why it matters. And so, however difficult it is in a court context, I think we have to moderate anything which adds fuel to the fire of any aggression and hostility between parents. And we need to be mindful that we're coming across a family at an incredibly vulnerable time. For the adults, and for any children, whether they're doing finances or children. It's a horrific time for families, and we need to be the adults in the room that don't make things worse.
Just to go through the 5 Ps in a bit more detail then, to try and understand how we can work within these recommendations. When the first one is plain English. And it's quite interesting to think about discussing the role that just using straightforward, simple language might have upon de-escalation of situations and conflict. And can you tell us a bit more about that?
Well, plain English, in one sense, it's stop using clever legal jargon so people don't understand what we're saying, so that they have to pay our fees and they think we need to use language that people can understand. That's the first thing. But I think there's a risk that by using legal terminology, we escalate what are very normal, usual family difficulties following separation into something legal where they may not be. I mean, it's very unusual for all parents to agree on everything at all times, whether they're very happily together or whether they're separating or whether they hate each other. It's normal for parents not always to agree. I was in a mediation with a couple yesterday and we were talking about the budget, the monthly budget form. And I said, please don't worry if you have different views about the numbers on certain categories. It's very usual for couples who are together and happy not always to agree on a budget and what's appropriate to spend on certain things. This is all part of a discussion. Now, I think the fear is that we, by using legal terminology, and I have a particular bugbear with the term dispute, is we take normal family situations and we ramp them up a gear by turning them into legal disputes. And I think that's all part of that escalating issue that we don't want to do. By using plain language, we call things what they are. There's a disagreement here about the amount in a budget form for holidays, which we need to look at. You know, we don't need to turn everything into a legal argument.
When I know before you mentioned about the language at the school gate and thinking about the impact that, for example, what I might be saying in a courtroom might have beyond the courtroom. I think it's fair to say that's something I hadn't particularly thought about before. And can you tell us a bit more about that kind of aspect?
Well, I mean, I think that's exactly what the Frameworks Institute people were saying, which is that, you know, my barrister says that, you know, you can just see how the kind of adversarial, the fight language feeds into any sides, people taking sides. The last thing a child needs at a time when their parents are separating and life is very turmoiled for them, the last thing anybody needs is a whole language of sides and whose side you're on. I ban the term sides, you know, when working with families. These are families. And the thing is, they'll go on being families, either with bad or good relationships going forwards. They'll be different. The families are changing shape. They're transitioning into a differently shaped family, but they're going to go on being parents to these children and ultimately maybe grandparents to children. And so it's all about de-escalating and not turning what is a difficult environment for any family into a legal drama. And I think that the language used in court absolutely arrives at the school gate. And that's why it matters. And just imagine if parents were turning up in court and judges were calling out aggressive language and dialing down, and that was feeding back. And then lawyers and barristers would be able to say to their clients, we are not going for the jugular because the courts don't like it. It's unacceptable.
When taking a step back from the courtroom, it's of course really important that first contact that a client may have with a solicitor in particular.
Yes.
And how that sets the tone going forward. Because of course, by the time it hits my desk, there's been an awful lot of legal involvement already.
Yeah. I mean, I think that there's a triaging role that all of us as family professionals have right from the start, is to identify risk. And in cases where there is anyone at risk, then a more formal approach is needed and a fast track into a family court, still with language that is not excessively adversarial. We can moderate our language, but that access into the risk route is essential. For many families, there may not be apparent risk as such, but there may be really entrenched hostility, conflict, upset. We know from the grief cycle that one of the stages of grief is anger. I think we see a lot of clients in the anger stage in our rooms who are going through separation. And it's very understandable, and the whole grief cycle takes time. But that means that we have to be building trust with our clients in a way that doesn't stroke and fan the flames of anger and hostility and hatred, but that protects their interests in a way which can point to the future of these family relationships. I think there's a massive tension in all cases where the solicitor or the barrister owes a professional duty to the client rather than to the family. And that's where the tension lies. But I think there's a progressive, wonderful group of young lawyers coming in who see the wider interests of the family and the mental health vulnerabilities of the children who are affected. So at the moment, in a traditional private client matter, which doesn't go to court, you have a parent represented against another parent represented and nobody speaking for the child. So another thing, which we won't discuss here, but love to another time, is the need to introduce child consultation and feedback into all cases.
We do in mediation, Helen.
We do that in mediation, but there's no reason why it shouldn't happen in a normal case with two solicitors. It would be great. It'd be really, really helpful for everyone, actually. For the child, we know it's helpful because the evidence shows it is. For the two parents, because it always shifts their thinking when they hear independent feedback from their child. And for the two solicitors, it would be really enlightening as well.
So moving on to another of the P's.
Yeah, we've gone off track, sorry.
We've gone slightly off track.
Sorry about that. Sorry.
So I am very guilty of this. Whenever I do a position statement, which I know you're not keen on that phrase.
Yeah.
Whenever I'm speaking in court, I do fall into the trap of saying wife, husband, mother, father, and so forth, when one of the recommendations is to try and essentially use people's names. Who'd have thought it? When again, can you just tell us a bit more about this?
Well, again, it came out from our discussion with the Frameworks Institute, but also much of the many of the papers we had in from these from the contributors. Using legal terminology is dehumanizing, and I think certainly for barristers, it distances one from the human beings whose lives are affected. The child, the applicant, the respondent, the mother, the father. Actually, we're talking about, in my case, Helen, Tom, Charlie, Christopher, Freddie. These are real people whose lives are in turmoil. Now, there is a question about how one uses real names. And I think we need to be respectful. And I would like it if at the beginning of any court hearing, the two people were asked what they'd like to be referred to as, Mrs. Adam or Helen or Mum. What's my preference? And be respectful, because we must remember in all of this that they are not pawns in our system. We are coming alongside them at an incredibly fragile time, and we need to make our system work for their family. And so I think personal names is important for them, so they're treated with respect, and so that the professionals don't just become so blasé about what's going on in another case and another case and another case, that we remember the human beings who are affected. And I think this is incredibly important in finance cases as well.
When moving on to one of the other P's, which I think is actually really important, it's a proportionate one.
Yeah.
Because there is a concern, I think it's fair to say, amongst both solicitors and barristers, that there isn't, through these recommendations, a watering down of what are incredibly serious matters that we deal with day to day.
Absolutely. Absolutely. And it comes back to those risk issues. And, the court ultimately is there for protection. Jude Eyre at the Nuffield Family Justice Observatory said that she views family separation as being like a bicycle, and the family court is the brakes. And it's there for safety. It's there for our protection. And it's essential that they operate well. It's quite possible to be firm and to protect a client, though, without using unnecessarily personally offensive and aggressive language, and using it in the context of coming alongside a family for protection rather than pitting parents against each other. I do realise, in fact, finding hearings and things like that, it's very difficult because they are effectively against each other, saying very different things. And this is one of the tensions, but somehow we need to make sure that the language is always proportionate, because the language that is appropriate for a family where there is somebody at serious risk of harm is completely different from that which is needed from two parents who can't agree on child arrangements, or from two clients who are having a different, they've been given different advice about how they should resolve their finances and the division of their pensions or their equity or whatever it is. That is a very different thing from people who are at risk of harm and who absolutely need. So I think it's really something for the barristers to be mindful of what level of risk are we dealing with here, and how formal and what proportionality applies to the language that we're using.
When Mr. Justice Peel made some interesting comments recently in WC and HC 2022, EWFC 22, just in case anyone fancies looking it up. When the quote I just want to read out, it's actually in his very first paragraph, so paragraph 2, which I think emphasises how important an issue he felt this was. And he said, parties and their legal advisors may be under the impression that to describe the other party in pejorative terms and to seek to paint an unfavourable picture will assist their case. It is high time that the parties and their lawyers disabuse themselves of this erroneous notion. When that's really quite strongly worded, but in a way that gets to the point, doesn't it? It's still saying, calling a spade when we have serious allegations, but not using unnecessary inflammatory language to do that.
I think that's absolutely right. And I think the difficulty is that as legal representatives, you don't want to look weak in front of your clients. But I think there is judicial authority to back this. Obviously, there's Peel J, but there's the president of the family division who says it is blindingly obvious that the language we have been using is combative and needs to change. He says once the penny drops, it seems so obvious. And so I think if anyone is in a tribunal where the other barrister or solicitor is taking a very personally aggressive stance, then I think it's only right and proper to say that in line with the recent moves towards moderating our language, you're not going to respond in the same manner, and you are going to choose to moderate the way in which any legal arguments are put so as not to inflame conflict, mindful of the children who usually are unseen and unheard in these proceedings, in many proceedings, obviously not in the more serious proceedings, but they won't be there, but they are affected. So I think, it will be a learning curve for the judiciary along with everybody else. But, most judges don't particularly enjoy hearing a case where it's become personally aggressive. They like to hear legal argument and make their rulings in a professionally dispassionate way, which doesn't become personal. And I think, if we can dial down the personal hostility that feeds from our clients, very understandably, into our cases, then that's actually ultimately helpful for the courts.
When moving on to the idea of problem solving, so I know I've already used the phrase position statement. I have to admit that's what I call them. They are very much bread and butter of my daily work life. Position statements, whether I'm writing them or reading them. I think it's fair to say of all the documents put before the court and that goes in bundles and so forth, they can contain some of the strongest language. When it might be said, though, that despite those issues, what difference would it really make if you were to move away from calling it a position statement to say Mr. Smith's approach? Would it really make a difference?
Well, I would say yes, wouldn't I? But the thing about a position is that it's a marker in the ground, which you then defend. So it's like a tug of war. you put your feet in the ground, you hold onto the rope, and then you're just going to pull against it, and you're not going to give an inch. And it shouldn't be like that in family cases. These are complex family difficulties. Most legal professionals have only met a small percentage of the family. In any family where there are 2 children, the legal professional is getting all their instructions from 25% of the family members. And we shouldn't be digging into unnecessarily critical and offensive and aggressive terminology. We need to be saying, this is our approach. And by doing that, we're effectively saying, what's your approach? I'm going to listen to your approach. And then we need to have a debate about the approaches and why you think that, the approach taken by your client is actually better for the family, and why you think that the approach taken by the other client may not be so good for the family. That's a whole different context here. We're now in a problem-solving environment rather than a fight. And the problem with the position statement is it sets up a fight. And I appreciate that's what you're doing in court, but actually we want to try and reframe that. We do want to try and reframe that, because we don't want the family court to be a battle zone. It's harmful. It goes back to the Professor Gordon Harold impact on the mental health chances for children who grow up through this. So I think maybe it's just playing with language. But the other thing about it is that a problem-solving approach reflects the Children Act and the change from custody of control and ownership, mine, to parental responsibility. We together have responsibility for the welfare of our child. It's a combined responsibility which needs to be exercised for the benefit of the child. And so a problem-solving approach reflects a parental responsibility approach rather than an ownership and a tuggle over rights. So I think the language actually is incredibly important to set the context for how this issue is to be resolved. No, I didn't use the term legal dispute.
No, you did not. Perhaps just moving then to the final P, which is positive futures. How can language move the focus then from the past to the future?
Well, it's a really interesting one, and please feel free to disagree with me on this, but I think that the family court, the litigation that happens through the family court is different from almost every other form of litigation, which looks back at something that went wrong and tries to redress that. Certainly that's the case in most forms of civil, commercial litigation of crime. There are some other land tribunals and things that may not be, but most litigation is about redressing something that has gone wrong. Family, particularly now we've got no fault divorce legislation to kind of overarch all of what we do. Family is about what needs to happen. So number one, so people are safe going forwards, so people are protected financially or physically or psychologically. And number two, so needs are met. And in a child case, it will be so that the child's needs to have a close and nurturing relationship with both parents can be expressed wherever it's safe to do so, or in a finance case, so that the needs of the family can be met as well as they can be from the resources available within the family. So it's all about how can we shape a future where people will thrive. It's not about who did what, when. I need to redress that wrong. And I think most in our society still think there's a bit about who did what when that should influence what then happens. And I think we need to be saying, I'm afraid it's all about what is needed so that everybody in this family can thrive going forwards, and so that needs can be met, the child's psychological needs and the family's needs for housing and finance. And, you know, let's take the sting out of it. So I think all our language has to point forwards to future. And if you ask most parents what they want from their children, do you want their children to thrive? Most parents would say yes.
Yeah.
Shocking.
So should we have a look at the word cloud now?
Yeah.
Helen, do you want to explain it?
Yes. So for those on the webinar, could you find a phone or something? And Sophie, if you'd like to share the word cloud, the Slido poll, there's a QR code in the coming up on the screen. You can either go to slido.com and type in that number, or otherwise put the camera on the QR code and it will take you to the code, to the poll. And I'm just doing mine now. And then you can start to answer the questions. What family words are harmful to family relationships? And you can enter as many as you like. And they will come up on here. They should be. Let's just see if they start coming up. Somebody's written the word versus. And if you want to put in several, I think you can do so by doing one and then entering another one. Yeah, custody versus opponent. Oh gosh, in family courts, is there still use of the word opponent?
Afraid to say there is.
I mean, that's a shocking term, isn't it? My opponent. You know, these are two very skilled legal professionals that need to be helping a family resolve their issues. Somebody's mistyped custody. That could even have been me. Fight versus award litigant opponent. So I think there are lots of words that we can probably come up with which are unhelpful. Let's just think about lots of others. Father, child, award, labels, mother, opposes, does not agree, fight versus alienating parent. And the whole concept of winning and losing. Who wins and loses in these? You know, I often say to clients, you know, one might win a battle, but you lose the war, really, if you get entrenched in this. Main carer, that's a real flashpoint, isn't it? Alienating parent, horrific term, a very dangerous term, not to be used lightly at all. Let's go on, Sophie, to the next Slido poll. Use the same QR code. The next one is what words are helpful to family relationships. So I'm going to refresh that. Okay, so we've now got one which is what words are helpful. If you just press refresh on your phones, it'll come up. The kind of words that aren't necessarily associated with family law terminology. Someone's written together, working together, yeah, better, collaboratively, joint. I mean, I think safety is an important word in all of this. And I think we need to think about safety for parents and for children, and children being safe, co-parenting. So when lots of people come up with the same word, it kind of highlights a very strong, that must be lots and lots of people saying co-parenting. It's such an important word, although I tend to think that cooperative parenting says it better, because co-parenting is like slicing a child in half and each have 50%. That's not co-parenting. That's a disaster for children. That's split parenting. But if people understand what co-parenting means, that's brilliant. Working together, resolving issues, the family unit, the focus on the family unit, constructive harmony, our children, that's such a great phrase, isn't it? Our children, amicable, the partnership, the future partnership that they will have. I'd sometimes give the example of, you know, imagining 20 years ahead when their 7-year-old daughter, or 30 years ahead might be giving birth to a first grandchild. And what's it going to be like then when she's in the post-labour ward? Is she going to be navigating who comes in and out of the hospital at what point? Or is it going to be okay at that point to be together and celebrate the arrival of a grandchild? Lots of really good things here. Family unit, collaboratively. Yeah, strong support for working together and co-parenting. Brilliant. Thank you, Sophie. Given the importance of what we're talking about here, just let's have a look at how the accolades of legal directories. Peers view her as a dangerous opponent and clients admire her tenacious and forceful approach. You need shin pads and earmuffs to deal with her, but there's no denying she's effective. A firecracker of a barrister, robust, fight her client's corner, G them up if necessary, famed for her uncompromising approach. She goes in hard for her client. If you're against her, you know it's fists up and a fight. When you need someone to fight your corner, she's unparalleled. And another, a good fighter who clients quickly warm to. Thank you, Sophie. I mean, what is that all about? I mean, what are we doing to children by promoting accolades. These are lawyers' quotes for other lawyers. And this is the accolade for being a good family barrister. We really need a radical rethink here. These legal directory quotes are profoundly harmful.
So we need to look at the sort of barriers and the sort of pushback.
That's exactly what I was going to raise, because there is a fair amount of pushback to these ideas that we're discussing.
Of course.
It does seem to be fairly controversial to try and have a move away from the terms we're also used to using. When I think really the key concern, certainly the key concern I would have, are clients' expectations. It's if I'm in a courtroom, I won't use the word opponent, but the other lawyer next to me may be using particularly forceful language beyond what I would potentially consider to be helpful or appropriate. And I'm acutely aware that sat behind me is my client, potentially my instructing solicitor. And what are my choices? My choices are to rise to that language, or to not, and continue to make the submissions in the way that I think are appropriate, and hope, essentially, that my client will understand what I'm doing, and so will the judge. But that's a very difficult situation to be in.
It is, and I think none of this is going to happen overnight. I think that we need to be mindful of the Professor Gordon Harold research of the impact of parental conflict on children. We need that. We need that pinned on our walls. We need that in our heads. And gradually it will change, because this language is unacceptable for the mental well-being of the children of the families that we work with. It's harmful. And so I think it's not going to happen overnight. And there will be some judges who will instinctively, if you're before Peel, Jay, Mr. Justice Peel, he'll be right on it.
He will. When I think that's part of the issue, isn't it? Judges vary.
They vary, but we can help judges and say, and I think rely on the Language Matters paper. It has the full endorsement of the president. He's asked me to speak on this at the president's conference with all the judges next month. He says it's blindingly obvious. You know, we need to rely on the mood of the meeting here, not this meeting webinar, but generally the mood of the kind of current, the cultural direction of family law at the moment is moving away from increased hostility, all towards resolving issues, with greater emphasis on how can we support families to resolve issues safely, appropriately, mindfully, in a child-focused way. And this is just part of that. And I think if we're before a tribunal where the judge hasn't picked it up, then we can say, well, I'm mindful of the current emphasis on language and why it matters, and I am going to moderate my language and not respond in the same tone that my learned friend has, or whatever you call each other, and take the high ground. And if the judge nods and said, thank you very much, I'd appreciate that, then you've won one for your client.
It's just interesting that we've just had a comment or a question, very much around this.
Yeah.
You know, that the person who sent this very much agrees with the need to change language, but struggle when she has, as she does at the moment, a particularly hostile, aggressive litigant in person opponent.
Yeah.
Who's personally rude in every email, aggressive at every turn. It's interesting. But so, I mean, really, I hope that, Joe, this comes from you. I hope that might, I mean, with the discussion we just had, that is an issue, and we're very much aware of it. And
why would that litigant in person know any different? I mean, the interesting thing is the litigant in person is expressing what the general public think family law is about, because that's what's known. And so this is all part of filtering it down to the public. But for that litigant in person, is it worth sharing the Language Matters paper on it? On the Family Solutions Group website, there's a page on language, and there's the webinar, and it starts with a few minutes of the president of the family division speaking about why combative language is not acceptable any longer. Now, it might be helpful for the litigant in person to understand that. Having said that, that litigant in person may well be somewhere on that grief cycle and unable to hear, but we can at least offer it so that they understand what's expected.
Certainly, I think it's fair to say that with the vulnerable witnesses programme,
Yes.
There's a recognition that there needs to be a change in practice. And from what I understand, that's actually moving along.
It is.
Successfully.
I think it's fair to say there was a huge amount of pushback from barristers, essentially being told that you need to reconsider how you were cross-examining certain witnesses. And when people, in full fairness, have been doing it in a particular way for many, many years, it's quite a culture shock to have to take what, having done the training very recently, is a completely different approach. But
Brilliant.
I almost sense that these kinds of discussions and ideas in regards to language may well start to become recognised as actually being necessary in a way that the vulnerable advocacy training has become.
Yeah. I mean, maybe I would say this, but I would say that one can end up with the higher ground by not getting into the pit for the fight. And, I think I've just seen that the comment in the Q&A that the litigant in person is just thoroughly unpleasant and difficult and nasty, and she may well be. But we retain the moral high ground by not succumbing to it, and by pointing out that it is not what's expected in family proceedings, and it's not helpful in addressing issues that need to be resolved. And let's not go there. And, but there are always going to be difficult people, and we deal with, in a way, lots of reasonable people who become difficult because of family separation and become difficult because of the system. So, this is a very challenging field for us to be working in and moderating our language. There's a comment about, was there something about resolution letters? Was there a question there about
I'm afraid.
Frustrating when those who are part of resolution correspond in a language which has an instantly hostile. I mean, the great thing about being, if the person's a resolution, is just point out the code of conduct. The resolution code of conduct is very clear about the kind of conduct that is expected, and, if necessary, report them to resolution. Unfortunately, it is quite common, but the conduct is there, the code of practice is there for us. I'm a member of resolution myself.
I mean, Hannah, we were talking about the professional directories, weren't we?
We were.
And that's,
yes,
and that's
which we,
yeah,
which we saw when that, I think, is something, and certainly as a junior barrister, looking at the directories, looking at what is rewarded and what you need to do to have a successful career, it does seem to me that there is a very strong emphasis on being quite aggressive in court, and that is being something that is currently recognised and is seen to be something to aspire to, when the reality is, even if probably nearly all of us, if not all of us on this discussion, agree that there is an issue with our language and the impact that our language has, we are also working professionals who want to do well, who want to have interesting
of course
cases,
and should do well.
But there is a concern that if you don't, put on a show, that actually might impact and harm your career.
Is that an area that you're looking at?
I think it's just really important that barristers have these discussions, within chambers and within the family bar. The fact of the matter is that the matrix of success at the bar is fighting and winning, and it's the default matrix, really. And there's ways of advancing a client's position and coming out with a successful outcome that don't involve getting into the pit for a fight. And I think that's the reframe needed here. And one can have incredibly effective advocacy, which is gentle and moderate, which is mindful of the future needs of the children and the desire for the clients that their children will thrive going forwards, and mindful of the research evidence, and is able to put forward legal argument in a way which is non-confrontational and doesn't escalate issues. I would say that's a real skill.
When I think, from my perspective, when I know we're trying to move away from battle language, but there is something quite nice about winning. there is something
Yeah.
quite nice about getting a good outcome for your
Absolutely,
clients.
and that's all fine.
Well, what I'm very mindful of, and I think what is becoming more apparent with the judiciary, is actually if you take a very aggressive approach, it can definitely backfire. And there are definitely quite a large number of judges now who really don't find that approach attractive. And instead being quite firm, but being fair in the language that you're using and being very professional can be very persuasive. And of course, if this is going to be something that we really need to think more about going forward, I certainly would much rather be at the front of thinking about this and thinking, how does this affect my practice, than catching up, once the ship is
unlearning a whole load of bad habits.
Exactly.
I mean, they're using moderated language in the Pathfinder courts and to great effect, and they're having great results at early resolution. The early resolution stats from the Pathfinders are really encouraging. And in fact, the two designated family judges who are running the two Pathfinder courts in Dorset and North Wales are speaking on the Nuffield Family Justice Observatory tomorrow from 1 to 1:30. It's an online, anyone can sign up for it. Be really interesting, but language is very much part of their changed approach in Pathfinder. And of course, it was used in the FDAC to great effect, moderated language. So, it's out there. And wouldn't it be excited if the family bar developed much higher skills in effective advocacy that was far more subtle and persuasive than just boxing gloves on and its fists in a fight?
Well, so that brings us very neatly, I think, Helen, onto what's going to help bring about change.
Yes, no, I agree. When, again, it's trying to make sure that this is clearly very important. It's something that we need to consider. But in practice, how do we get all of us as lawyers to actually move forward in this? And it seems that potentially a practice direction and actually having something more concrete than trying to create a culture change might be more effective.
I personally think a practice direction would be really helpful. So people have got something to wave in front of, well, for example, the litigant in person that's causing such grief, but also for their clients, so they understand why, they're not paying all this money for a barrister who's, not aggressive. But it's more than a practice direction. It's culture change. It's culture change. Language doesn't change by law. It takes all of us to reflect. And I think for solicitors to engage in reflective practice with their colleagues about their cases and about the dynamic and the role that they are bringing to their cases and the language that's being used and how that might be adapted. For all of us, it's a learning curve. We all get bits of language wrong at times. And, this is just a learning curve. And I think for barristers, whether it's reflective practice or whether it's a bigger discussion around that whole proportionality issue and what types of language are appropriate for what types of situations in court, I think this has to be an ongoing discussion, and it's not something that will simply happen by rule change or practice direction, although that may well come, we'll see.
Certainly, a very informal straw poll of some of my colleagues who still function frequently in the courts, in fact, all the time in the courts, they felt that a practice direction would be a very significant step, because again, it places a marker. That's a very, inexact science, but nevertheless, it is actually quite interesting that without that statement, instinctively people often want to do, if you like, what they feel is right in any event, but it makes it a lot easier when there is actually a marker there that says, that this is something that is required as well. And so just as a matter of interest, because I guess what we've been thinking about as well, Hannah, was, it's really for you to ask this question about practice, really, because I'm very conscious of the fact we've literally got 5 minutes before everybody will be going home for tea or perhaps something stronger. So really, what we can do to improve our own practices and really encourage wider change. Yeah.
Yes. So what we can do personally. And
what would you say, Helen, about that?
I think the taking this forward as a discussion, reflective practice, and of course, when clients come to us, we can frame our retainer right from the off and say, just so that you're aware, I am adopting this, this new approach to language. So although I absolutely am there to represent your interests, and I will do everything to enhance your, I was about to say position, your approach. Actually, the new tone of family law and the way I'm going to correspond with the solicitor is always now in a very constructive way. And in fact, mostly solicitors seem to get on the phone to each other these days rather than write long letters. So, to frame the way in which the solicitor works, so the client is not coming in thinking they're buying a big fighter. For barristers, as you say, you're at the coalface, and I think, I think these are important discussions with your colleagues and with your judicial colleagues, when they come into chambers and you're talking with them about what's going on. I think this is a really important area. How do we sit comfortably with the research that shows the harm to children, the long-term mental damage, lifetime damage potentially to children by fueling conflict between parents? And how do we ensure that we get good outcomes in court cases that are more investigative and less adversarial?
Well, Helen, thank you so much. It's been a really fascinating time for us, I think, and we're very, very grateful to you both. And also, I want to say thank you to Sophie Hicks, who has made it's been making the technology work. I'm afraid that we have a slight technical problem in here, and as much as I think there might be some chat or some questions coming up that we can't actually read, but we will get back to you on any questions that might be there.
I can read a couple. Shall I? One is, do you propose judges have training in this area? Yes, that's underway. And the magistrates are very much working on that. And I hope more webinars are hosted to encourage this approach, so both solicitors and barristers can align their approaches and be reminded that clients have to live with the outcome of the decisions made. It's far better to achieve comfortable outcomes and end things with battle wounds. Very
right too. Well, I'm quite clear that this is a movement, this is an issue, more of a movement that Chambers is really going to want to take up. And so from my point of view, Helen, I'm hoping that we might be able to persuade you to come back and join us again later this year for another of these webinars, because I certainly have found this extremely helpful.
Extremely helpful.
So thank you very, very much indeed.
Thank you so much.
It's been a pleasure, but really has. So just to let everybody else, to let the people who've been joining us this afternoon, let everybody know that the next webinar of 40 Bedford Row is on Thursday, the 11th of May, and it's a public law update. And that's provided by Amanda Jepson and Mark Challoner. And I can see that there are questions and things coming up, but we've literally run out of time. We've got one bit less than a minute, I think. So again, thank you all very much for joining us today. And I hope you're going to be joining us again on the 11th of May. So thank you very much.